3 million pages of evidence, thousands of unsealed flight logs, millions of data points, names, themes, and timelines connected. You are listening to the Epstein Files, the world's first AI-native investigation into the case that traditional journalism simply could not handle.
Welcome back to the Epstein Files. Last time, we walked through life as registered offender and tested what the records could actually prove without speculation. Today, we are examining Julie K. Brown and mapping what the documents show about actors, timeline, decisions, and institutional response. As always, every document and source we reference is available at epsteinfiles.fm. So the first record is the November 2018 Miami Herald investigation titled Perversion of Justice, which re-examined the 2008 plea deal and identified over 80 victims.
And this is really where the focus shifts. We're moving from a biography of the case to an audit of how that case was forced back open.
We're looking at the mechanism of exposure.
Exactly. The narrative can get lost in, the sensational parts, the famous names. But what we're doing is looking at the paper trail. The trail that Julie K. Brown and the Miami Herald didn't just follow, but created.
It's a trail of litigation as much as it is one of reporting.
That's the key.
So we're essentially treating the journalism itself as a documented forensic intervention in a legal process. The first document to pull up is from the Pinpoint database, the one referencing the Perversion of Justice series.
But we also have the actual legal filing. File 1212 tag Miami Herald versus Epstein 2018.pdf.
Right. This isn't just a newspaper article we're talking about. This is a court docket.
So let's look at the scope of inquiry defined in that 2018 investigation.
Yeah.
The stated goal wasn't just to recount the crimes from the 90s or early 2000s.
No, the objective was very specific.
It was an audit of the 2008 non-prosecution agreement, the NPA.
The Herald series puts forward a very precise thesis.
It does. It posits that the federal justice system effectively shut down a major sex trafficking probe to protect one wealthy, well-connected defendant. And they didn't just, suggest it.
They brought the document.
They brought the receipts. And here's the number that really drives the whole series. Over 80 victims. I want to pause on that number.
You have to. Because forensically, it's a massive contrast to the official record at the time. If you look back at the original federal scope or the state charges Epstein actually pled to, you're talking about a handful of names.
Single digits.
Single digits. The gap between single digits and 80? Well, that's the entire story right there.
That numerical discrepancy, that's the hole in the institutional record.
Yeah.
The Pinpoint database shows that Brown tracked down women who were never even interviewed by federal prosecutors.
No, whose interviews were just disregarded.
Completely. I mean, if the FBI says they have 5 victims and a single reporter goes out and finds 80, that's not a clerical error.
No, that's a systemic failure to investigate.
It's an audit of the witness list.
The Herald investigation was essentially rebuilding the victim pool that the Southern District of Florida, the SDFL, had failed to secure in the first place.
But what really sets this apart from standard reporting is the litigation. We have to keep coming back to that document, Miami Herald versus Epstein 2018.
It's a critical distinction.
It is. The Miami Herald didn't just report on the sealed documents. They went to court and litigated to get them unsealed.
They became a party to the proceedings.
Yes. The investigation was running at the same time as the legal action to unseal the docket entries in the civil case between Virginia Drift and Ghislaine Maxwell.
So the journalism itself acted as a lever?
A mechanical lever, exactly. Without the Herald filing that motion to intervene, the entire archive of evidence we're discussing today, it likely stays sealed forever.
It's a different model of journalism. Usually the reporters are outside the courthouse, waiting for a comment. In this case, Julie K. Brown and the Herald's lawyers walked inside and basically sat down at the plaintiff's table. They were using the First Amendment not just to print a story, but to force a judge to change a ruling.
In a civil case they weren't even a part of originally.
It's a forensic intervention.
Right.
They weaponized the freedom of the press to break the seal on the record.
And that's the intervention that lets us see the documents in this next block. We have to look at the Perversion of Justice series itself and this document from the House Oversight Files.
Bait-stamped document 016552.
Right. This file gives us a window into the legislative oversight that came later, but it all roots back to the reporting.
The core legal anomaly that the series exposed, and that the House Oversight Files later corroborated, is the non-prosecution agreement itself.
We should look at the actual text.
I have it open. Epstein plea deal 2008.pdf. It's a surprisingly short document considering the amount of damage it did.
Just scroll down to the immunity clause.
Here it is. The United States agrees that it will not institute any criminal charges against Jeffrey Epstein. But then it keeps going. It extends that non-prosecution to any potential co-conspirators of Epstein.
Potential co-conspirators. That's the phrase. That's what Brown locked onto.
It's so unusual. In our past reviews of plea deals, immunity is transactional, right? You give up the bigger fish to save yourself. You trade up the chain.
Always. You trade up. Here, the so-called bigger fish is the one getting the deal, and he's securing immunity for unnamed, unknown associates.
He didn't trade up. He traded sideways to protect his entire network. The document doesn't list their names.
No.
There are no social security numbers, nothing. It just grants a blanket amnesty to anyone who might have possibly helped him.
It's a legal blank check. And the records show this was a specific violation of the CVRA, the Crime Victims' Rights Act.
That Bates stamp document, 016552, it outlines this very clearly.
The CVRA requires that victims be notified of plea negotiations, that they have a right to confer with the prosecution.
But the documents Brown unearthed showed that the victims weren't just not notified, they were actively misled.
The email traffic cited in the pinpoint database is, well, it's damning. You have federal prosecutors emailing the victims' lawyers saying no deal has been reached.
On the very same days they were drafting this immunity clause.
It wasn't just silence, it was active misdirection.
A procedural firewall.
That's what it was. If the victims had known about the deal, they could have filed a motion to stop it. By keeping them in the dark until the ink was dry, Alexander Acosta's office made sure the deal couldn't be challenged.
Not until it was already too late. That's the perversion in the title. It's not just about the light sentence, it's the procedural subversion.
The institutional players are key here. We see Acosta's name over and over in the database and the Herald filings. He was the U.S. Attorney for the Southern District of Florida.
And the reporting maps the decision-making directly to his office. But this brings us to a really crucial cross-reference. We have the reporting from 2018, but does it hold up against the records from the time? From 2006?
This is probably the single most important document in the stack for verifying Brown's work. The letter from Michael S. Reiter to Barry E. Krischer, May 01, 2006.
Let's look at the actual document. It's dated May 1st, 2006. This isn't an email printout. It's a formal letter on official Palm Beach Police Department letterhead.
From the Chief of Police, Michael Reiter.
To the State Attorney, Barry Krischer. This is official correspondence between the two main law enforcement agencies on the ground.
And read the quote, the specific one we flagged for the audit.
Chief Reiter writes, quote, I continue to find your office's treatment of these cases highly unusual, end quote. He also urges Krischer to, quote, examine the unusual course that your office's handling of this matter has taken.
Highly unusual. In forensic terms, that's a 5-alarm fire. When a police chief puts in a formal letter to a state attorney that their behavior is highly unusual, that is bureaucratic code for.
You are corrupt or incompetent.
Right. He is creating a paper trail for history. He lists case numbers. He references specific affidavits. He's practically shouting in this letter.
And Reiter goes even further in that file. He talks about submitting probable cause affidavits and case filing packages. And then he says, it is pretty clear to me that Mr. Krischer did not want to prosecute this case.
And there's your audit trail. You have the police chief on one side, formally submitting evidence for felony charges, and the prosecutor on the other, formally declining to pursue it in the standard way.
Brown's reporting in 2018 served to exhume this letter. To place it in the context of the federal deal that came later, it links the local failure to the federal one.
It proves that the perversion of justice narrative wasn't just some retrospective invention. It wasn't Brown looking back 10 years later and guessing what happened.
No, she found the document that proved the institutional friction existed in real time. The police wanted to make an arrest. The prosecutor wanted to let him go.
And look at the date, May 2006. This is 2 full years before the federal plea deal was signed. The evidence was there, the probable cause was there, the victims were there.
The system just chose not to see it.
It chose to ignore it.
So let's move to the next block, how she actually broke it. The methodology, the intervention. We're looking at the document Epstein Docs, Julie Brown, Miami Herald Media Company, v. Ghislaine Maxwell. This is the Second Circuit Court of Appeals.
This is the mechanism we talked about, the motion to intervene. Brown and the Herald inserted themselves legally into the civil suit between Virginia Giuffre and Ghislaine Maxwell.
Which was the defamation case. We've discussed it before. It was settled, but all the documents, the depositions, they all remained under seal.
And the Herald's argument was simple. The public has a right to see them.
We need to look at the ruling from August 9, 2019 from the Second Circuit. It's referenced in the Epstein Docs 2023-02 source.
In it, the court vacates the lower court's order. It unseals the summary judgment materials.
The language in that ruling is really significant. It talks about the presumption of public access to judicial documents. It basically said you can't use the court system to hide evidence of a public crime.
Especially when that evidence directly contradicts a government action, like the NPA.
So the expert analysis here is it's about causality.
It is. The documents prove that without this specific legal intervention by the Herald, without them spending the money, hiring the lawyers to fight this battle, the 2,000 pages of documents would have stayed sealed.
The Perversion of Justice series wasn't just a story about the past, it was an active legal strategy that changed the future of the public record.
It forced the court's hand.
Which brings us directly to the impact of the reporting. We have the SDNY indictment, 13 tag USV Jeffrey Epstein indictment 2019.pdf. A timeline audit here is revealing.
Let's just map it out. November 2018, Perversion of Justice is published.
July 2019, the Southern District of New York indicts Epstein.
The proximity is undeniable, but it's the content, too. The SDNY indictment cites conduct from 2002 to 2005.
The exact same time period covered by the 2008 NPA.
And this is the legal pivot. The 2008 NPA supposedly granted him lifetime immunity for this exact conduct, but the SDNY, a different federal district, effectively overrode the agreement.
The Pinpoint database also references Alexander Acosta's resignation in July 2019.
The records show a renewed, intense interest in his 2008 decision-making, an interest triggered directly by the Herald's document releases.
Acosta held that press conference defending the deal. He said they had to work with the evidence they had at the time.
But Brown's investigation proved that the evidence at the time included the Ryder files, which his office apparently ignored.
The 2019 indictment basically confirmed the entire thesis of the 2018 reporting.
It did. It confirmed the conduct was criminal, it was federal, it was continuous, and that the 2008 resolution was completely insufficient. The legal system only corrected itself after the press's audit made the previous position impossible to defend.
Let's go deeper on the specific documents Brown used. Block 5. We're looking at the flight logs and the black book.
Right, the verification of sources. When Brown was interviewing victims, she needed to corroborate their stories. She couldn't just print allegations.
So the flight logs became the primary tool for that.
Let's open the file, 01 Hag Epstein flightlogs.pdf. This is often the most sensationalized document in the whole archive, but we need to look at it the way an investigative journalist would.
She wasn't looking for headlines about presidents or princes.
She was looking for patterns. She was looking for a timesheet.
A victim says, I was taken to New Mexico in 2003. That's a memory. And memories are fallible in court.
But if the log says N370SJ, Teterboro to Santa Fe, June 4th, 2003, then suddenly that memory has a spine of steel.
It's the corroboration engine.
And Brown used really strict source discipline here. She didn't write, this person was on the plane, therefore they are guilty.
No.
She wrote, Epstein had the access and the logistics to move people around the world without any scrutiny.
The logs also demolished the defense that Epstein was just some local guy with a solicitation problem. You don't fly a Boeing 727 for a local solicitation charge.
Right. The logs prove the federal nature of the crime crossing state lines. That's the key metric.
State lines changed jurisdiction. The logs proved that the Palm Beach police were out of their depth, not because they were bad cops, but because the crime scene was at 30,000 feet.
It's also important what the logs don't prove. They place a person on a plane at a specific time. They don't prove what happened at the destination.
Brown's reporting was careful, and our audit has to be, to use these as timeline verification, not as proof of guilt for every single passenger.
The Black Book is similar. It's a contact list. It establishes a network. It proves Epstein had access to these people.
It validates the scope of his influence, which was a central theme of the Perversion of Justice series, that his connections protected him.
But a phone number in a book is not a criminal act. The Herald used these raw documents to build an infrastructure of credibility for the victims' testimonies. That was their function.
Now let's look at the depositions. Evidence Block 6. We have the Ghislaine Maxwell 2016 deposition and the John Alessi deposition from the Jouffre v. Maxwell case.
This brings us right back to the litigation we just discussed. Brown's reporting was centered on the existence of these depositions long before they were ever unsealed. She knew that in the civil case, questions were being asked that prosecutors had never bothered to ask.
The timeline of the unsealing is key. Maxwell's deposition was unsealed in April 2020, released in July. But the Herald was reporting on the contradictions well before that, based on the court filings that were available.
So let's look at the content. The deposition has specific, repeated denials by Maxwell about any knowledge of underage activities. She denies seeing misconduct. She denies participating. Just flat denials.
And here's the friction again. We take that deposition with her sworn denials and we lay it right next to the letter from Michael S. Ryder. The police affidavits describe recruitment. They describe the role of his associates.
The police file says one thing. The deposition says the opposite. And that discrepancy, that perjury trap, is what Brown's work identified.
Yeah.
The thesis was that if you compare the buried police files with the sealed civil depositions, you would find the crime.
And that's exactly what the unsealing eventually proved.
Let's spend a moment on John Alessi. His deposition. This isn't a victim. This is an employee, a house manager.
His testimony gives this granular, logistical detail about the operations of the household.
And employees are often the best forensic sources. They aren't emotional about the events. They're logistical. Alessi isn't describing abuse. He's describing the daily schedule, the arrivals, the departures. It all lines up with the flight logs.
He talks about the massage book, the fact that a physical ledger was kept.
That one detail is devastating for the defense.
Mm-hmm.
I mean, if this were just casual dating, you don't keep a ledger.
No.
A ledger implies commerce. It implies volume. Alessi's deposition describes a revolving door of young women. He describes cash payments.
And Brown realized that Alessi's mundane description of, cleaning up or scheduling flights was actually a description of a trafficking operations back office.
It normalized the abnormal. To the staff, it was just another Tuesday. To a journalist like Brown or a federal prosecutor reading it years later, it was a confession of conspiracy.
So let's move to the synthesis. What is the pattern that emerges when we overlay all of Julie K. Brown's work onto this stack of documents?
The pattern is one of institutional protection clashing directly with ground-level evidence.
The institutional protection is the NPA. It's Acosta's decision. It's the silence from the state attorney, Krischer.
And the ground-level evidence is the Ryder letter, the flight logs, the victim testimonies that Brown found.
And Julie Brown's work is the bridge between the two.
That's it. Her work was the bridge that moved the evidence from sealed police archives and sealed civil dockets onto the front page of a newspaper, and from there onto the federal docket in the Southern District of New York.
The documents prove the system had all this information in 2006?
It did, and it chose to ignore it. It took an external auditor, in this case a journalist, to force the system to finally acknowledge its own records.
We also have to be very clear about the unproven elements. We are auditing the record, not the rumors.
That's right. The Herald exposed the process of the plea deal. It exposed the identities of the victims and the failure of the institutions. But specific claims that are often associated with this case.
Blackmail tapes, intelligence contracts, Mossad connections.
Those remain unproven by the primary court records that we're reviewing today.
We see references to intelligence in some secondary sources, but in the Miami Herald filings, in the Ryder letter, in the SDNY indictment, do we actually see hard evidence of a state-sponsored intelligence operation?
We do not. We see evidence of immense wealth, of influence, of sophisticated legal maneuvering. We see a coercion architecture implied by the properties listed in the 2019 bail memo.
The layout of the rooms, the security systems.
Right, but we do not have documentation for a state-sponsored intelligence operate or, hidden facilities beyond the known properties.
And we don't have the blackmail tapes themselves. We have descriptions of cameras. We have testimonies about cameras being everywhere. But the actual files, the tapes, they are not in the pinpoint database or the court exhibits.
And that is a critical distinction to make. We have testimony of surveillance. We do not have the product of that surveillance in the public record. So we have to classify those elements as unproven.
Okay, summary. We traced the 2018 Herald investigation all the way from the 2006 Ryder letter through to the 2019 Second Circuit ruling.
And the documents confirm that the Perversion of Justice series was the primary catalyst. It was the thing that forced the unsealing of the legal archive that we now possess.
It's the definitive audit of how the Epstein case was reopened.
No question.
Next time, July 6, 2019.
You have just heard an analysis of the official record. Every claim, name, and date mentioned in this episode is backed by primary source documents. You can view the original files for yourself at epsteinfiles.fm. If you value this data-first approach to journalism, please leave a 5-star review wherever you're listening right now. It helps keep this investigation visible. We'll see you in the next file.